Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. In the April 24th, 2025 court order directed toward the defense's motion in limine concerning multiple expert witnesses that the state is proffering, the court, I believe, has given the defense quite a gift, hints on what the defense may want to at trial object to. It's buried in a footnote on page number 7, and I wanted to bring it to your attention here. But let's look at who the expert is and what he is going to be testifying to at trial. Page 6, Michael Douglas. Mr. Douglas is a forensic accountant for the feds and is disclosed to testify to financial transaction data for defendant, the 4 victims, and the 2 other roommates. Mr. Douglas's initial disclosure identifies by category and date range the financial transaction data that he intends to testify to, and also appends Mr. Douglas's report of specific transactions found within these individuals' financial data. Mr. Douglas's supplemental disclosure identifies more specifically the financial data associated with the defendant that he intends to discuss, and also identifies video evidence obtained showing the defendant's ATM withdrawals. Mr. Douglas's disclosure makes clear that he is intended as a fact witness and is only being disclosed as an expert in the event the court determines his testimony was based on specialized knowledge under IRE 702. So what this means is that the state, although Mr. Douglas was disclosed to be a fact witness, and a fact witness is someone who saw, heard, knows something based on personal knowledge, versus an expert witness who is being proffered because of some specialized expertise in a field. So what the state did here is that Mr. Douglas was disclosed as a fact witness, but also in an abundance of caution, I believe. In the event Judge Hippler finds that he is in fact testifying as an expert, he was disclosed as both. The opinion continues, moreover, although the supplemental disclosure appears to indicate Mr. Douglas will offer an opinion as to the defendant's spending habits, and his testimony will be limited to factual changes in how the defendant spent money. For example, the court gives here, the disclosure notes defendant only conducted ATM withdrawals on and after the date of the homicide and ceased using his debit card after November 10th, 2022, whereas prior to November 10th, he had regularly used his debit card. The court continues, there is no indication Mr. Douglas will attempt to opine, that means to give an opinion about the reasons for this change in spending habit. And we have to go to page number 7. Just that they occurred. So in other words, not going to give an opinion as to explaining why this change in spending habits regarding Mr. Koberger's ATM withdrawals before the 10th of November versus after the 10th of November. Just that they occurred. And here's where the footnote 12 it comes into play. Footnote 12, without more, the court has concerns about the relevance of this testimony, but defendants hasn't challenged it on this basis as yet. So although defense hasn't brought up the possible irrelevancy of this type of testimony by Mr. Douglas, Judge Hippler has concerns about it and notes that defense has not raised this issue of relevancy yet. Big hint, I believe, to the defense regarding possible objections at trial. The opinion concludes by saying, thus, there is no basis for excluding or limiting Mr. Douglas's testimony based on disclosure concerns. Not relevancy, ladies and gentlemen, but disclosure concerns. This will now conclude this episode of the Indie Zone podcast. My name's Kathy. Thanks for joining us here today.